because it's more danger to have a weapon just laying around where a child could pick it up or somebody else could pick it up than you're picking it up and calling the police and saying, hey, I found this weapon. And what I'm reading in the police report is that the officer comes up to him and he's like, yes, I do have this weapon, you know. And are you Mr. Garza?
I am.
Counsel, have you received all discovery and did you review that with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, I see in the notes that there was a competency evaluation done.
Yes, Your Honor. It was, and it came back that he is competent, and I agree with that.
All right, and he's already been deemed competent by that court and that judge?
That's correct.
All right, thank you. Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
Whoa, pause here. The state is downgrading the charge to attempted possession. That's a massive shift, from straight-up unlawful weapon possession to a third-degree felony attempt. Translation? They are softening the blow, but prison time is still on the table.
No, Your Honor, we are not. We are proceeding for the lesser included attempted possession to make this a third-degree felony.
No objection.
Breakdown. A third-degree felony in Texas carries 2 to 10 years in prison and up to a $10,000 fine. That's not pocket change. This isn't a slap on the wrist. It's real time behind bars.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of attempted unlawfully carrying a weapon with a felony conviction as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted unlawful carrying of a weapon with a felony conviction. They're asking that your punishment be assessed at 2 years in the prison and you to forfeit the firearm. Did you understand that to be the plea?
Ma'am.
Defense?
Yes, it is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places? I'm sorry?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
Okay.
All right, State 2 may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty.
things get complicated. The defense claims Garza was literally on the phone with 911 to turn the gun in when security spotted him. If that's true, it's the kind of technicality that makes you ask, should he even be charged at all?
And the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this case is kind of an unfortunate one. Mr. Garza is a resident of Haven for Hope. He suffers from some mental health issues that have been checked out, and he is, I believe, competent and has been confirmed, but he does have problems related to prior injuries that he's had. And this particular day, this weapon was found downtown under the bridge by some other boy, and Mr. Garza picked it up to try to turn it in. He was literally on the phone with 911 on UTSA property whenever he was spotted with a gun on property, and that's what led to this. We've looked at pursuing this to a trial and all that, but Mr. Garza has been locked up for more than 6 months, and he has elected to take this plea. He was in possession. He is a convicted felon, so it meets the technical, allegations, but that was the reason that Mr. Garza has chosen to move forward with this case.
So a gun was discovered, and he was calling the police to turn it in.
He took it. It was during the church under the bridge. He went to use a phone from one of them, which is on the UTSA property, and was, as I understand it, on the phone when UTSA security saw him and came over. And here we are.
Well, my thing is, technically, is that a violation of the law? Yes. But is it a violation of the spirit of the law? It appears that it is not. So I don't know if there's proof of what he's saying or not. Based upon what I'm reading, it's not what's being said. I don't see it in the police report. So.
And with the nature of the offense and the people around, the witnesses, it's a challenge.
To the judge here, this is raw honesty. She flat out says the law might technically fit, but it doesn't feel like justice. That's a rare moment in court, when the letter of the law and the spirit of the law collide.
That's what the defense is faced with, and that's the reason Mr. Garza has elected to.
And I'm assuming that's the reason why the state is proceeding on the lesser included.
As well as the minimum.
All right. Then the court will find you guilty of the lesser included offense. The court. All right. So here's my thing. We can go off the record. I understand why the state would proceed on the lesser included offense, and I may be overstepping my bounds here. But if what is being said is true, this just doesn't seem just to the court. I mean, if somebody finds a gun and they're picking it up and on the phone to call the police to say, hey, I found a gun, come and pick it up. Legally, is it possession? But this is not what this law is meant for. Am I wrong? And I understand state why you're reducing it, but do we have any proof of this? I'm telling you all, if there's proof of what he's saying, that he was on the phone, and it appears that there was the gun didn't have any, wasn't loaded or anything.
Your Honor, you do speak to a good point. If there is proof, there has been requests for things that have been alluded in the police report, things that would have corroborated. The state has not been able to receive those things. There have been discussion with defense. The state understands if it came to he said, we understand and believe the report. Things have been requested that we don't have. And
who would have these things?
We've requested specifically without, jumping around the 911. We do not have that. We cannot corroborate it.
So where's the 911? Does the 911 not exist?
It's been requested, and
the missing puzzle piece, the 911 call recording. If it exists, it could prove Garza was trying to do the right thing. But without it, the state's case is ironclad. Question for you. should cases hinge on evidence the court can't even track down?
I haven't gotten word back. Now, we believe with the reports, we have the elements.
Yes.
Yes.
No, I mean, you do have the elements, and you actually have the elements for unlawfully carrying a weapon with a felony conviction, because he has a felony conviction. He was carrying a weapon. So I can sentence him now, or if you want to wait, I can not sentence him today, and they can see about the 911 call.
And Judge, I'll talk to Mr. Garza. This case was set for a couple of weeks from now. Mr. Garza has asked me to push it up to move the case.
So, Mr. Garza, do you understand what's going on?
Just a little bit.
All right. So here's the thing. You're not allowed to possess any weapons if you have a felony conviction. And then there's some things, if you have a family violence, you're not an affirmative finding of family violence, you're not allowed to possess any weapons either. And that's what this law is for, right? And so from reading the police report, you're guilty, right? Because you had a weapon. But if you found a weapon, you picked...
Courtroom Strategy 101. The judge offers Garza two choices. Take the 2 years now, or wait 2 weeks to see if the 911 tape surfaces. Risk versus reward. What would you do? Lock in the deal today, or gamble on proof that might never show up?
Picked it up, and you were calling the police to say, hey, I found this weapon. Could somebody come and pick it up? To the court, that's not what this law was meant for, because it's more danger to have a weapon just laying around where a child could pick it up or somebody else could pick it up than you're picking it up and calling the police and saying, hey, I found this weapon. And what I'm reading in the police report is that the officer comes up to him and he's like, yes, I do have this weapon, and yes, you may search my backpack and everything. So you can discuss it with your attorney if you want. We can recall it back in 2 weeks. Here's the thing. If it turns out that they can't get the 911 call and you still want to go forward with the 2 years, you'll have the 2 years and you'll get credit. So if we come back in 2 weeks and you end up getting 2 years, guess what? You're still going to get credit for the time that you were waiting for those 2 weeks. It's just you'll be at the Bexar County Jail and not at the prison. It's completely up to you. But for the court, I don't think, and I could be wrong. If I'm wrong, somebody correct me. I don't think that's the spirit of that law. So.
Judge, I'm in agreement with you. It's up to Mr. Garza.
Okay, so can you explain that a little better to me?
All right. So the state has offered you 2 years.
Okay.
I will follow that 2 years if the state, if they go and they're not able to get the 911 call, because they say they've been trying to get the 911 call. If they are unable to get the 911 call, you'll still have the 2 years. So your waiting 2 weeks is not going to change your position as far as the agreement that's been worked out by your attorney.
We'll be there. We'll be back in a minute.
Or whatever the court says.
I mean, if I have no other choice, but yeah,
No, you have choices. These are your choices. I can sentence you to 2 years today, or we can see if the state can find if the state receives, I don't want to say fine, if the state receives the 911 call, then if the state receives the 911 call, they may decide to do something different than what they're doing now, which may be in your favor. But at the end of the day, worst case scenario, you're sentenced to 2 years.
okay.
Wait 2 weeks. Well, it's up to you, but
You want to discuss it with him in the box and then just let me know? All right. Thank you.